hear Mr. Clark if he's still here. I know he possibly had to run, but I want to make sure to state that recognizing that home builders do still have, and we're working through some issues, it's my hope that there may be some tweaks to language to ensure that any affordable housing ordinance adopted by a local government, there's actually provisions that once they agree to either ratios or density or FAR, that they stick to it. And right before approvals, there's not sort of a bait and switch. And I think that's the concern I've heard from the home builders through this process. So I do understand that concern. This is a needed tool, and I'm certainly willing to work. Is my understanding they're going to try to draft up a couple amendments, Mr. Chairman, to the substitute that you're about to adopt. Okay.
So before we do that, let's go ahead. We have a substitute here. So your bill lists 12 things that you're sort of empowering localities to do to encourage affordable housing. One of those had to do with the building code, which is an area we generally try not to touch here in this subcommittee. And the second was it the required set-asides? Yeah, and so we've drafted a substitute that gives you 10 of the 12 things you asked for in your original bill. And can I get a motion on that substitute? Second. It's been moved and properly second. We adopt the committee substitute. As many as favor of the motion will say aye. Aye. Those opposed? All right, the substitute is before us. You understand the difference is we just took 2 of your bullets out. We took out number 4 from the original and number 6. And so, again, we don't want to mess around with the elements of the building code, and we didn't want to create a set aside. All right. So is there anybody in the audience wishing to speak in favor of the bill? I'm sorry, let me do this way. Is there anybody here opposed to the bill? Any opposition? All right, anybody here in favor? Come forward, keeping in mind that nobody spoke against it. Keep your comments to an appropriate length, given that the more you say, the less likely it is to leave. Go ahead.
Long enough to say my name. Randy Grumbine, Virginia Manufactured Modular Housing Association. We're in support.
Thank you.
Hi, Kevin J. Vonk, Planning Director for the City of Richmond, and the city supports this bill.
Thank you. You guys are doing a great job so far. Keep it up.
Sheila Herlihy with the Virginia Interfaith Center for Public Policy. We also support the bill.
Thank you.
Isabel McLean with Virginia Housing Alliance, and we also support this bill. We think it'll be a really important tool for all localities to be able to have this ability. Thank you.
Thank you. And?
Mr. Chair, Joe Lurch with Virginia Association of Counties, also speaking on behalf of VML in support of the bill. Thank you.
All right, thank you. Now, did you say there were maybe some potential further amendments to the substitute that you thought somebody might have? Did Mr. Clark want to come forward? Do you have some suggestions for improvement, or are you guys good with what it's got? Or work it through the rest of the conference process?
Mr. Chairman, I think I explained it. He's given the thumbs up in terms of the nature of the home builders' issues is once an ordinance set, what they don't want to do is have either density or floor area ratios pulled back right before development approvals. And so I do understand that concern. I think that Mr. Clark is looking to provide some level of assurance if the locality adopts an ordinance, that it's actually carried out throughout the development process and not a bait and switch later on. And I do understand that, and I think he wants to figure out a way to strengthen that language, and I think amenable, and I think localities would be as well, if everyone can agree to the same rules of the road. And so I know this will be back before full, and so I'm okay with working to figure out what that right language is with you, Mr. Chairman, as well as the home builders.
Gotcha. I just wanted to make sure I understood the ask. The ask is to keep this moving along, but keep an eye out for maybe some tightening up on some of that language. Okay. Delegate Coiner, Delegate Thomas?
Mr. Chairman, provided that piece in the valley can be had, I have a motion for the appropriate time.
Okay, let's hold on. Let's go to Delegate Coiner first, and then we'll come back to you, Delegate Thomas.
Thank you, Mr. Chair. So I understand the point where you have an ordinance, and then oftentimes what will happen, though, folks will come in and get you to proffer larger lot sizes or larger different things can happen through the process. I think we can probably borrow from the statute that I can't remember what year it passed. I will find it before we get to full to be helpful, but I do think we can tighten up that language, which will be helpful to ensure that what we intend to be those affordable housing units are preserved. Happy to be helpful there.
All right, thank you. Delegate Thomas?
Move to report as substituted.
Second.
With the substitute.
It's been moved and properly seconded that the bill report with substitute. The clerk will open the roll. The clerk will close the roll. My bill report 6-2.
Thank you, Mr. Chairman.
Thank you. All right, I'm going to take one more quick one, and then I see that Chairman Locke has gotten into the room. I want to make sure we take her bill up too. So let me take Delegate Perry. Or, I'm sorry, Senator. Jeez, I did it again. I did it again. Still a senator.
Still a senator.
All right, Senator Perry, deepest apologies. You have a bill with having to do with the Human Rights Act. Why don't you go ahead and explain that Senate Bill 350 to us, please?
Yeah, this is Senate Bill 350, and this is a bill that changes a little bit of the statute on, right now the way that the law currently stands is that if you have an allegation of discrimination, you believe you were discriminated against, you can take that complaint and you can file it with one of two people, one of two groups, the EEOC, which is your federal component, or you can file it with the state component. What then happens is those two groups kick off an investigation. There's a work sharing agreement with the state component. Sometimes they will kick those cases over to the federal government, the EEOC component, to look at and try and make a determination. The statute says that they have 180 days to look at those cases and to make a determination of what they found, what their findings are. At that point in time, you can request a right to sue letter. And what that means is you're requesting of those entities the right to go into court and take your case into court and proceed. What is happening now, or what was happening prior to my drafting this legislation and filing it, was that sometimes those right to sue letters were not being issued by the appropriate offices at all, which meant that you could actually never take your case into court. So this just seeks to fix those issues and allow people, after those investigations have been able to either be completed or they're not going to be completed and they've requested their right to sue, to go ahead and be able to get into court to have their cases heard. I'm happy to take any questions.
So, Senator, this is sort of like a default proceed, right? If you do your due diligence, you wait, the time expires, then you can proceed by default as opposed to being stuck.
That's exactly right.
Okay. Any questions from members of the subcommittee? Anybody in the audience in opposition to this bill?
Move to report.
It's been moved to report. Is there a second? Second. All right. It's been moved and probably second to report. I see we have some folks in favor online. Believe me, I think you're going to like the result if we proceed without you. So there's been a motion properly seconded to report. The clerk will open the roll. The clerk will close the roll. That bill reports 8-0. Thank you, Senator Perry. And I know I said that you'd be next, Senator Locke, but Senator Rome, I think you have another also very easy, quick one. So I'm sorry, I'll be right with you, Madam Chairman. Senator Rome.
All right, thank you, Mr. Chair. After 3 years of introducing this bill, we finally are in the position where everyone should be happy, and if they're not, we will have words. This is SB 281. So SB 281 would allow for families to gain interment rights at family cemeteries by providing proof of kinship to those interred. I bring this bill to you because in my district there are historic African American, Native American cemeteries which have been sold to private buyers. Because of this, descendants of family members buried here have lost the ability to access these cemeteries and put their family members to rest with their ancestors. And so, long story short, I have presented this bill in front of general laws for each of the last 3 years. This bill has now gone through 4 subcommittees, 3 full committees, and a partridge in a pear tree. And in between, Delegate Coiner and I worked in the off season on this with a lot of back and forths. And I believe we now have peace in the valley all around. I will also note that Jeff Cruz from the Catholic Conference is here, who can give a thumbs up because we included an exception for churches, both leased or owned, or for property leased or owned by those. And yeah, that's the bill.
All right, thank you, Senator Rome. Delegate Coiner.
Thank you, Mr. Chair. Echoing the hard work on this bill, my concerns were not with the rights to cemeteries. It's those of us who work in land use and in the title examination and making sure it was easy for us to handle these. At the appropriate time, I move to report, Mr. Chair.
All right, is there anybody in the audience wishing to speak in opposition to this bill? All right, now it's the appropriate time.
Better not.
All right, it's moved and seconded to the bill report. The clerk will open the roll. The clerk will close the roll. That bill reports 8-0.
Groovy, thank you.
All right. Senator Locke. You have a nice, easy bill as well. It passed the Senate unanimously. I don't understand what the big deal is, but there might be one. So this is identical to my bill, which I love. But why don't you tell us about Senate Bill 3? I'm not putting my thumb on the scale. Don't say that. Senate Bill 354.
I love mine too. Senate Bill 354 deals with local real estate disclosures, seeks to prohibit the establishment of mandatory real estate disclosures by local ordinance. This bill will ensure that real estate licensees, buyers, and sellers have one place to go to find out what disclosures must be made, how to make them, and who needs to make them in a real estate transaction. That's what it does.
So is there any questions from members of the committee? All right. Is there anyone wishing to speak in opposition to the bill? All right, this time there is. So let's hear from the opposition first, and then we'll hear from the supporters, but let's see what the opposition's about.
All right, Mr. Chairman, members of the committee, Patrick Cushing on behalf of the Metropolitan Washington Airports Authority. Of course, we operate a 2-airport system, Dulles Airport and Reagan Airport. We are opposed to the bill, but I do need to apologize to the patron and you, Mr. Chairman, because this is not a bill that we had on our radar in the first half of session. We picked up on it about halfway through session by the time these bills had really started to clear through the floor. Everything that the patron said, I don't think we can disagree with. I think it's important that we have one place in the state code to look for real estate disclosures. It's a transparency tool for realtors and for home buyers. The issue that we have with Dulles Airport and Metropolitan Washington Airports Authority is this bill does something very specific, and that is it eliminates a disclosure requirement that has existed around Dulles Airport for 30 years. I want to talk a little bit about the history on that and why it's important to Dulles Airport. There are a number of other folks from Loudoun County and United Airlines and the Virginia Aviation Business Association who are going to speak after me, so I'm going to focus my comments on the impact of Dulles. In 1993, Loudoun County and Dulles Airport got together and realized that there are 2 freight trains running at each other. The first was massive growth at Dulles Airport, and the second was massive growth within Loudoun County. The biggest issue faced by Dulles Airport were complaints over noise. And the noise is from the international airport operations. We're the largest international airport in the Commonwealth. We have the largest planes in the world flying in and out of Dulles on a 24/7 basis. In 1993, Loudoun agreed with Dulles in discussions on putting an overlay district around Dulles Airport that matched up with noise decibels where new developments in Loudoun County within this airport overlay would have to come with disclosures when the houses are sold, when the homes are sold, to notify landowners that they are in an existing flight path of Dulles Airport. This is not a blunt tool. This is not a giant blob around Dulles Airport. I've shown many of you a map of this. It is a very specific overlay that is aligned with the decibels that are maximized when you have flight paths coming in and out of Dulles Airport. This has existed for 30 years. About a year and a half ago, and I think this is where some of our realtor friends, and I know that they will comment on this, picked up that an amendment in the Loudoun County zoning ordinance clarified that this disclosure applied in the resale of homes. Now, it's an important tool for Dulles because of the volume of noise complaints that go to Congress, they go to the FAA, they go to Loudoun County, and they come to Dulles Airport. The concern for us is when we hear from the FAA and from Congress about restricting flights, changing flight paths at Dulles Airport, it's a potential constraint on further growth. We've seen that at Reagan National. At Reagan National, we have a different situation. We can come in and out over the Potomac River, which helps address some of those noises. We don't have that tool available at Dulles Airport. So with the real estate disclosure in place around Dulles at this point, we have a tool that A, makes sure that homeowners know when they live and buy a home in that flight path, that they know that from the start of their home purchase, which is the largest purchase they'll probably make in their lives. And the second is, if they do continue to complain about noise, we have a tool to go back to those homeowners and say, look, we realize it's a problem. We told you signed this disclosure. So the final point that I would make is, Dulles is designed to accommodate about 50 million enplanements a year. We are at about 24 million. There's a lot of growth that's going to happen. I'm not saying that they're going to get to 50 million enplanements, but about 10 years ago, the Commonwealth invested $50 million to ensure that the cost structure at Dulles was attractive for growth for United Airlines and other airlines. So we have challenges to our growth. Noise is a big concern. The Commonwealth has made that investment. And so what we have done is we've offered to both patrons an amendment that would preserve the existing language of the bill while adding in a real estate disclosure in the state code by amending the military air installation disclosure. That military air installation disclosure was instituted in 2005 to help protect airports under a round of BRAC closures. We think there is a lot of similarities between Dulles Airport and our military air installations. So we have precedent for doing this, and this is the committee that is responsible for reviewing real estate disclosures. Both patrons have let us know that that's not a friendly amendment, but we would still advocate for that amendment. And without that amendment, we are unfortunately going to have to oppose the bill.
Thank you.
Thank you.
We've got a couple people online, so a couple more here. I got one more in the room. Let's go ahead and hear.
Sure. Mr. Chairman, members of the committee, my name is Edward Mullen. I'm with the Reed Smith Law Firm on behalf of United Airlines. Very much associate my comments with those of Mr. Cushing. I think he summarized the history very effectively. And I, again, apologize to the both patrons for not catching this prior to crossover. I think this comes down, I agree very much with the fundamental underlying purpose of the bill, which is to avoid a patchwork of local disclosures where that's a trap for the realtors and the unwary of not knowing where to look. But again, our concern is one of transparency. There has been increased development around Dulles over the years, and United during that time has invested hundreds of millions of dollars and employs 6,000 plus people, I think, and has plans to increase that. So we've made a very sizable investment, but jet noise is a constant concern, particularly as development comes around. And from our perspective, people knowing what they're getting into when they buy a home and knowing that they may be in a flight path that is not necessarily intuitive is really important. Whoops, there you go. Thought that belonged to somebody. It's very important that people know what they're getting into, so even if they do raise a complaint at a certain moment, we can say, you knew it. And so, again, with great respect to both patrons and the process, we must respectfully oppose absent an amendment that was described.
All right. Anybody else here in the audience wishing to speak in opposition? Come on forward.
Mr. Chairman, Bud Oakey, President of the Virginia Aviation Business Association. Again, the same sentiment. We didn't find out about it until late, and we are sorry that we're here in this position. The requesters in the real estate community did not reach out to us and get our comments previously. We look at Virginia's airports as economic drivers for the communities they serve. Noise and consumer issues are number one problem that we have, not only in Virginia, but everywhere throughout the United States, and I would dare say every country that deals with airports. The rules and regulations were put in place for a reason, and that was for consumer protections for all of us. The FAA has been very, very clear to airports and to the entire aviation community in this area on working with localities where airports are located to get in and to assure that the public knows so that we can work to mitigate the complaints that people have with their locally elected and state elected after the closure of the cell when they realize they're in the flight path that might extend out miles from the airport runway. So with that said, and due respect to the patrons, we oppose this bill, but are willing to work with you all throughout the year to try to come up with a reasonable solution.
All right. And finally online, we have Courtney Sidner. Apologize. Courtney. Ms. Sidner.
Yes, thank you. Thank you, Mr. Chairman. My name is Courtney Sitnor. I'm a senior deputy county attorney with Loudoun County, which, as has been said, is the home of Dulles International Airport. And I would like to go ahead and just associate myself with the comments of the three gentlemen who spoke before me, agree with everything they said, including wanting to share that we weren't aware of this bill until late in the process. So we apologize for our late coming to you with our concerns about the bill. But Loudoun County does oppose the bill for all of the reasons that have already been stated. What I would like to share with you all, though, is that why to Loudoun and to our Board of Supervisors this notice is so important. As was mentioned, our Airport Impact Overlay District regulations were updated just in January of 2003. It was the culmination of a multi-year process. There were public hearings before the Planning Commission and the Board of Supervisors in 2022. I was in the boardroom during the Planning Commission public hearing in June of 2022, and I sat in the room and listened to resident after resident after resident who came forward and spoke about the impact of the noise on their homes, how it affects their use and enjoyment of their homes, and their frustration with the fact that they said they either did not receive notice or that the notice they had was not meaningful, they didn't understand it, etc. So the Planning Commission heard this, county staff heard this, the Board of Supervisors heard this, and that was why it was so important not only to maintain the notification requirements that we've always had since, as we said, 1992, but to clarify that it applies not just to the initial purchaser, but to subsequent purchasers of the homes. There's really no reason why only the initial purchaser of a home should be notified of the noise impacts from the airport. The impact is the same whether you're the first purchaser, the second, third, fourth, 10th purchaser. So that is why this is so important. It's not something that we take lightly, but it is a very real issue for our constituents, and something the board and the Planning Commission both debated extensively during that process. So that's why we oppose the bill. We are absolutely open to an equitable resolution that addresses the concern of making sure that realtors across the state have a central location and know what notices have to be provided. We have no objection to that, and we are happy to work with them to accomplish that, but we would like to do it in a way that does not come at the expense of Loudoun County home buyers who would basically know. It wouldn't even be a matter of, is the notice effective? It would be, there is no notice. And so for that reason, we oppose this bill. Thank you.
All right, thank you. I have a quick question for you as the county attorney, or assistant county attorney. So this is in your zoning ordinance, right? So what is the remedy for a failure to disclose? I mean, is it a zoning violation? Is it a right to rescind the contract? Does somebody have to repurchase it? I've never been able to figure out, and that's been a source of some frustration. What happens if you don't?
So I think, yes, at the core, it is a zoning violation. It is something that we talked about and that we did address when we were presenting it to the board, that this is not a matter that we would be able to rescind sales. That's not even our objective. Really what our objective is to be able to work with the real estate community to make sure that the notices are provided. We're not trying to penalize people, but we want to have a mechanism and a tool so that we can make sure the home buyers do get the notice for all the reasons that were already stated.
Thank you. Appreciate that. All right, Nick, Mr. Sabo, I see you're moving around a little bit. I'm getting a little dizzy, but if you don't mind, you go ahead and unmute yourself. We'd be happy to hear from you if you can just please stand still. You need to unmute first, too.
Unmute. Oh. Can you hear me now?
We can hear you now.
Okay, I apologize, Mr. Chair. Thanks for the opportunity to speak with you. On behalf of the Virginia Airport Operators Council, we must also oppose this bill. We believe that, as the previous panelist has indicated, a locality's ability to prescribe measures to protect its airports through transparent disclosures. They're an FAA best practice on how we uphold compatible land use, how we ensure that we are acting neighborly with our communities. And so we believe that is in our best interest. And so for those reasons, we would be open to agreeable amendments that ensure that airports can be part of the disclosure process. But we feel like it's a tool in our toolbox that we don't want to lose. So for those reasons, we must oppose the bill.
Thank you. All right. We've got some folks here in the room to speak in favor of the bill. And then we'll have some questions, I think, from other members of the subcommittee. I got to jump in because I'm the chairman. Go ahead.
Thank you, Mr. Chair, and members of the subcommittee. Erin Corman with the Realtors. Despite what you've heard here today from the opposition, this bill has to do with one thing, and that is the power historically given to this statewide body to review requests for real estate disclosures. With all due respect to everyone that seemed concerned that they weren't notified about the bill, this bill dropped the same week as every other bill. I've read them all, and because it is a local versus state power bill, we did notify the localities and the local associations. So back to this bill, this body created the Virginia Residential Property Disclosure Act in 1992. This is where all the real estate disclosures and buyer beware statements are housed in our code. It's where there's information on how disclosures are to be made, termination rights, liability, and the development of standard forms for licensees to use to make these disclosures. It's also where we find that real estate licensees have a legal requirement to notify their clients and any unrepresented party of what their legal rights and obligations are with respect to disclosures in this state. It is critical that this power and regulation remain with one central statewide body, allowing localities to establish their own mandatory real estate disclosures, as the opposition said, would lead to a patchwork of disclosures and compliance rules all around the state. Dulles Airport is a perfect example. Dulles is important in Loudoun County, but floods are important over on the shore and by the beach. We have data centers, we have landfills, prisons, helicopter pads, bus depots. I could go on forever because there's different issue in each locality, okay? But real estate licensees are licensed on the state level. They can practice anywhere in the state. They often practice across many localities, and it would be almost impossible for them to find all of these local laws and comply with them. One last very important issue that seems to have been lost here is that this bill does not prevent a locality or anyone for that matter bringing a bill before you requesting a real estate disclosure in the state. It merely establishes that the General Assembly is the proper vehicle for establishing those disclosures. With respect to the 30-year ordinance that apparently has existed in Loudoun, we are aware of the 30-year ordinance that was changed in 2023. It's our opinion that the bill language as it stands would not affect that original ordinance. This bill is limited to 3 parties: licensees, parties to a contract, and their agents. And it defines a mandatory disclosure as a notification made by a homeowner or their agent. It does not talk about applicants, developers, builders. It's only talking about those subsequent sales where licensees are representing these clients. So with respect to the 30-year ordinance, this is not doing away with that. This is doing away with a change, apparently, according to them, a change that was made in 2023 would be affected by this bill. But the point of this bill, again, is to reestablish that the state is the one with the power to make real estate disclosures. I'm happy to answer any questions. The builders had to leave, but wanted me to also let you know that Home Builders of Virginia fully support the bill.
All right. Anyone else wishing to speak in favor? I don't think we have any online. Delegate Coiner, you had a question?
I don't. I was going to speak to the bill.
Okay,
Mr.
Delegate
Chair.
Coiner, speaking to the bill.
Thank you, Mr. Chair. So the consistency that this bill brings forward is extremely important. It's important for those who are licensees, and this is their job, that we know that there is consistency. You are licensed to practice your business in the state, not locality by locality. It is also extremely important for buyers and sellers that they have consistency and that they know what's to be expected and that this is consistent at the state level. And the third, I will say, it's really important, or for those who are practicing attorneys in this area when things go wrong, because having consistency across the Commonwealth when disputes occur is extremely important so that we are able to utilize our expertise and ensure that folks are treated fairly in the process of real estate transactions. I am extremely supportive of ensuring that only the state is responsible for the disclosures and that they are consistent across the Commonwealth. And I support the bill as is, Mr. Chair.
All right, thank you. Delegate Thomas.
Thank you, Mr. Chair. The real estate attorneys are coming out today. I guess, I don't know if this is for the pro or the opposition, but my question would be, what would be the impact if this passes today and I guess the pro side or the opposition just brings their own bill to rectify the issue? Can I just get some education on that? Actually, from both sides.
We'll do one of each, sure, but let's be brief. Go ahead, Aaron.
I'm not sure I understand the question. I mean, if this bill were to pass today,
I'm sorry, if we didn't pass this bill.
You know what I mean.
Sorry. Yeah,
sorry.
You knew what I meant. We both know. Okay, all right.
If this bill were to pass, like I said, any locality, any person, anyone could bring a bill next year requesting a disclosure for any item, and then this General Assembly would do what it always does, which is vet and balance the philosophy of buyer beware in our state and consumer protection, and then make a decision as to whether it rises to the level of going into the act.
Yeah, Mr. Chairman, Delegate Thomas, I think it's a timing issue right now. And so what this bill does, the effect of this bill, I agree with everything that the realtors have said in their testimony. We have a timing issue. If they eliminate local authority, which we do not have a problem with and agree with, if you eliminate that today and don't replace it with a corollary in the state code, which is what we are asking for, and which amendment has been, again, offered to the patrons, but said thanks but no thanks. That is our issue, is the timing issue, because if this passes, we now have a series of home sales that will take place over the course of the next year, and for how many years out that will not have disclosure. And so because this is the subcommittee that deals with disclosures, it is fully within your authority today to say, wait a minute, let's fix this timing issue. Let's go ahead and put this one disclosure into the code. Let's amend the military air installation disclosure, and let's fix both of these issues at the same time. So we're asking both issues to be fixed today, not for just one of the issues to be fixed. I guess that's probably how I would phrase that.
Yes, gotcha. And as you know, we have talked about different ways that the disclosure can be done, and our Disclosure Act contains different kinds of disclosures, mandatory disclosures versus a list of buyer beware disclosures. And there was some conversation about which approach, and you guys as well have insisted on one particular approach that you all are sort of stuck on. So it's not simply a matter of no thanks, but no thanks, just to be clear. All right, with that, the committee, what I will tell you is that we have had some other disclosure bills that came before here. We have one that's a persistent issue down in the senator's area, which is how we do flood disclosures. And again, whether we should make those mandatory or not. A couple of years ago, we looked at that issue, and we had sort of a hybrid situation where we have, depending on the nature of the area you live and how persistent the flooding is and so forth, we have some affirmative disclosures, and we also have some buyer beware disclosures. And we've asked that bill was referred to the Housing Commission to look at, again, that balance. And I am more than happy to write a letter, or to have our Uber chairman write a letter to say, including in that study of flood disclosures, we want you guys to look at the issue of airports as well and come back to us with a recommendation for how we might make that disclosure next year. So, that is, I want to be clear about that. I make that commitment to everybody, regardless of what happens with this bill. I'm sure that the General Laws Chairman in the Senate might be willing to do something similar, but let the Housing Commission know that, yes, this is an issue that needs to be addressed, and the Housing Commission is equipped to do that. They're already set up to look at these disclosure issues in other areas. I think adding the airports wouldn't be too big a burden. Delegate Carr is on the queue.
Okay. Just a question. This is kind of intuitively maybe answered, but just as for the Loudoun United Airlines Dulles folks, do you have any examples of like real world scenarios to indicate that the additional transparency is needed through disclosures for families buying a home near Dulles? I mean, we can guess, but I mean, I need some real concrete stuff here.
Yeah, Mr. Chairman, Delegate Carr. I think probably most recently some examples that we have around Dulles is there's a specific neighborhood that was built out while COVID was going on and airport operations were down drastically. Folks that moved in, they saw airplanes overhead, but they did not see the volume of air flights that takes place in a fully operational Dulles airport. And right now, our biggest noise complaint concentration is coming from that neighborhood. And so that, this goes to well, isn't it obvious you live next to the airport? And sometimes it's not as obvious. COVID was one example. A second example is you have a number of home buyers coming from New York and outside of Virginia that are looking at homes in Northern Virginia. They're relying on their realtors, they're relying on virtual tours and so forth to look at homes. And one of the things that they may not realize are the volume of flights, not just during the day, which is when I think most homes are shown, but at night. With international airport operations, we're flying 24/7, and our biggest jets are taking off in the late hours of the night and early morning as they're going off to Europe, Asia, Africa, and other places. And those nighttime flights are a big concern. Thank you.
All right, Delegate Coiner.
Mr. Chair, speaking to the bill and then a motion.
All right, you can do either one or both.
Well, Mr. Chair, I would move to report and speaking to that motion.
Okay, is there a second?
Second.
All right, it's been moved and seconded the bill report. Delegate Coiner.
You know, I guess I'm thankful in hearing the only example that we have is that it was at maybe a once in a lifetime thing that hopefully will ever happen in the middle of COVID when airlines are less. You know, my concern here is I often think if we start letting people piecemeal, then folks who are doing the piecemeal use it as a reason not to address problems with folks. You know, when we have consistency, when you're required to deal with problems, we have a landfill in our area and people complain about it. And if we had a thing that just required a disclosure, they could say, well, it was disclosed to you that there was a landfill, versus having to be a good business as a neighbor and address the concerns when they come up to folks because they're required to, because we didn't simply allow them to disclose that it might be inconvenient for you. So with that, Mr. Chair, I still support my motion to report the bill as it's presented before us.
All right. Anybody else wish to be recognized? If not, the clerk will open the roll. The clerk will close the roll. Senator Locke, your bill reports 8-0. Thank you very much. All right, Senator French, I'm sorry. I missed you there. You probably had an easy one, but maybe you enjoyed the conversation. So.
I won't be here for that anyhow, so we're not too
And then Senator Eber, you have a number that you have in a row, so we'll get you right after that. All right, Senator French.
Thank you, Mr. Chair and committee. I'm here to present Senate Bill 701. Senate Bill 701 is a property rights bill. Basically, it says if you go to your locality and present what you're doing as far as a building present, a building and getting a permit and get into the process and by no one's real fault realize that something wasn't picked up from the locality and you may be within a setback or something by a little bit, that they have to give you a variance and let you go on if you have significant money involved in doing it. It's kind of simple, I think, and I'd like to answer any questions for anybody if they have any.
All right, anybody have any questions for the senator? All right, is there anybody in the audience wishing to speak in opposition to the bill? All right, anyone in favor of the bill? Go ahead, Mr. Grumbine.
Mr. Chair, we see this as a common sense bill. Randy Grumbine representing the Virginia Manufactured and Modular Housing Association, that a consumer goes through expense and proceeds in good faith, that they should be allowed to continue.
All right. So this is going to been a motion properly seconded the bill report. The clerk will open the roll. The clerk will close the roll. Your bill report's 8-0. Thank you.
Very much.
All right, Senator Eben, which one do you want to do first?
Thank you. Senate Bill 422, I think, might be the easiest to go through. Senate Bill 422 is identical to similar to HB 993 from Delegate Tran with dealing with junk fees on the Residential Landlord and Tenant Act. What the bill basically does is it says that a landlord wouldn't be able to charge you a fee for repairing the landlord's property, nor would they be able to, in the form it's in now, charge you for making rent payments if there's a free form of making rent payments available. In other words, they couldn't charge you to pay your rent if they accept checks. They can't charge or if they don't accept checks, they couldn't charge you for making an online payment. This is very close to what you passed of Delegate Trans, and understand she wanted to conform her bill to mine in the Senate. So I'm hoping that we'll pass this one as is.
Right, yeah, I think that's right. I think we voted on this policy essentially, but it is right, Delegate Tran prefers this, so when her bill's heard on your side, it'll conform to this. And so if we want to be consistent and avoid conference, which I think we're trying to do as time runs down, would be, the right motion would be to move to report this bill as is. I'm seeing the advocates shaking their heads, yes, this is the one they want. It's been moved and seconded to the bill report. Clerk will open the roll. The clerk will close the roll. That bill reports 6-2. All right. That was easy. Next one.
Now I've got Senate Bill 672, amending the Condo Act and Property Owners Association Act to confirm association authority to collect and use fees for services provided by association, whether the services are provided to a lot or to a common area. This legislation is necessary to restore order after some confusion resulting from a recent Virginia Court of Appeals decision in Burkholder versus Palisades Park Owners Association Incorporated that misreads longstanding provisions of these statutes and calls into question association authority to pay for services provided by the association unless the fees are explicitly authorized in recorded documents or statute and fund only the common areas. Associations are routinely required and expected to provide services, some that benefit only lots, like trash removal, cable and internet service, property maintenance and utilities, and associations sometimes fund community building events like a holiday party or something. Like any other business, associations also have operational and administrative expenses, such as filings with local and state government agencies, insurance coverage, or professional services like accounting, tax prep, management, engineering, and legal services. And under a broad interpretation of the case without confirming this authority in statute, an association may not collect or use fees paid by homeowners for those services. Associations must have the financial resources to fund expenses, whether those expenses are the result of mandates or to meet resident expectations. We received reports and testimony at another hearing on the bill that owners are using the case to argue they're not required to pay for services. These challenges are expensive and divisive to communities. So SB 672 is essential to provide certainty and predictability to Virginia citizens who live in communities served by associations. And I think if you look at the bill, it's pretty straightforward and something that one would expect that you could that we wouldn't construe this chapter to otherwise prevent an association from levying or using assessments, charges, or fees to pay the association's contractual or other legal obligations in the exercise of the association's duties or responsibilities. That's the bill, and I'm prepared to answer questions, and I also have some folks who'd like to weigh in support.
Okay. Is there anybody here in the audience who would like to testify in support of the bill? You guys want to come forward and briefly? They're both.
Yes, Mr. Chairman, I'm Don Boswell. I'm a homeowner and on the board of Twin Hickory Association. I'm also the chair of the CAI Virginia Legislative Action Committee. It represents people from all over the state, and we speak in support of this bill. We really need this bill. Thank you.
Thank you.
Good afternoon, Mr. Chairman, subcommittee members. My name is Willis McLeod. I'm the president of the Somerset at West Ridge Homeowners Association. We have 220 homeowners in that community. We have an annual budget of almost $900,000. And the way this bill would affect my community is if we had to go back and amend our documents for everything that inherently is required for us to service and pay for, that would create a tremendous problem for us. For example, my association, like many others, expends assessment funds to perform maintenance requirements that are not expressly written in our documents. For example, the Somerset Declaration states that the associations are responsible for the maintenance, repair, and replacement of the common elements like the roofs. We recently replaced our roofs and purchased a $25,000 warranty to protect that $1.3 million upgrade. Although purchasing a comprehensive warranty is a common sense procedure in this case, an owner's objection could have limited the warranty protection we could obtain. Similarly, our 216 decks are limited common elements that have shared maintenance responsibilities between owners and the association. Although the association is charged to inspect the decks, we do not have the engineering expertise to perform this task. Like Palisades Park Owners Association, we hire a third-party firm to assist in performing this engineering assessment. Again, this is a reasonable step that can now be challenged by a resident. SB 672, if adopted, will enable associations like myself to continue to provide the services and support required to manage their communities effectively. Therefore, I strongly encourage you to adopt and support SB 672.
Okay, thank you. And Mr. Gianni.
Thank you, Mr. Chairman, and thank you to Senator Eben for bringing this bill. It's an important bill to correct what we believe is a misreading of the statute. The statute's always permitted the ability of an association to charge for services to a lot, and that's the critical problem with the ruling of the court. It has far-reaching implications, as you'll hear perhaps from others. I know there are another number of folks online as well. Much like localities, the scope of duties and responsibilities for associations are in their charters. Their charters are governing documents that are recorded among the land records. These documents are not always easy to draft. Having done them myself, I know that you can't always think ahead for every contingency. The documents provide a foundation for the communities, but they also address what community members expect and deserve in their services to their lots and to the common areas. A quick example, if this case is allowed to stand, an association cannot provide services to a lot if the documents do not explicitly provide that the association has authority to provide those services. And you've heard Senator Eben in his remarks include some of them: trash removal, not in documents, not in ordinance, and it's provided by community associations. It's a burden that community associations relieve the cities of and the counties. It is an important service. Without the ability to charge for services to lots, which this case we believe misreads, they cannot do that. So we ask your support for the bill. It's important, and glad to answer any questions.
Mr. Gianni, real quick before you go, a question. So you talk about the foundational documents, the declarations and so forth. This statute wouldn't override any charter that explicitly limited the board's ability. It would only sort of fill in the gaps where the charters are silent. Am I understanding that correctly?
Mr. Chairman, you're exactly correct. The Property Owners Association Act has always been read to fill in gaps, unlike the Condominium Act, which created the lifeblood and created the ability to create a condominium. If the documents explicitly prevent it, this statute will not change that.
All right, thank you. That's, I think, an important distinction for folks to understand. I appreciate that. Ms. Taylor.
Good evening, Mr. Chairman. Sarah Taylor, City of Alexandria, here in support of the bill. As a locality, we often negotiate ongoing responsibilities with associations for things like trash removal, maintenance of publicly available open space, stormwater management, private roads, and those are done through our land use negotiations. And if they are not able to pass those costs on to their homeowners, then we cannot negotiate those into our land use. And so we think the trickle-down effect for localities is significant. And in looking at the court case and this bill, our planning and zoning folks, our attorneys had concerns, and really appreciate the senator bringing this and would ask for your support. Thank you. Thank you.
All right, we have some folks online. It's okay not to repeat what you've heard before and just associate yourself with those folks' comments. But with that said, I'm going to start with, is Clea Benson on? Ms. Benson, can you briefly tell us who you are and why you support the bill?
Yeah, hi, I'm Clea Benson. I'm the board president of the Potomac Yard Homeowners Association. We're a community of 725 townhomes and condos in Alexandria. Our community is already experiencing the adverse unintended consequences of this court decision. We have two litigious individuals in our community who are threatening to sue us if we provide basic services like repairing our irrigation system. They say we can't paint our mailboxes, we can't shovel snow. They are even saying that we cannot provide the services that we have agreed to provide through the city, that the city has required us to provide through development documents, like paying into the city's transportation management plan. This has already caused our legal bills to skyrocket. dealing with this. Everybody in our community, except for the two litigious individuals, is very distressed about it. So please, please support this bill. Thank you.
Thank you. Mr. Keith Elliott. I'm sorry, let's see if I'm Bernie Guthrie. Is Bernie Guthrie on? All right, Keith Elliott.
Good evening. Thank you for your time, Mr. Chairman. My name is Keith Elliott. I work for a management company called CAMP. I've been in the industry since 2011, and there are certain circumstances that this bill needs to solve for the management of these associations. As was previously mentioned, the local jurisdictions like to have the HOAs. And if there isn't good management of these HOAs, if there isn't good facilities and taking care of removing trash and doing the other things, then what's going to happen to these associations? The tree canopy is going to go, the environment may go wayside. And my budget for my association is $7.5 million. And I had mentioned in a comment before about trash. I'll add to it that the association I manage has a guardhouse, so they supply a guard to that house. And that's not explicitly authorized in the governing documents. So I do please ask you to support the bill.
All right, thank you. And then finally, Mr. Tiago Becerra. Oh, you just muted yourself. You were unmuted before. There you go.
Thank you. Good evening, Mr. Chairman. My name is Tiago Becerra. I'm speaking in support of the bill. I'm a community association attorney, a resident of Burke Center Conservancy in Fairfax County, and a member of the Virginia Legislative Action Committee of the Community Associations Institute. I want to echo all those comments that have been made by those in support of the bill, and particularly those comments from Ms. Trigiani. Please vote in support of this bill.
Thank you. All right. Is there anybody here in the room wishing to speak in opposition to the bill? All right. Seeing none online, we have Ms. Carrie.
I think there is one online.
No, that's right. I'm going online. I meant if there anyone. I was first coming back to the room for any opposition. Seeing none online, I'm coming back online. I see Ms. Carrie Burkholder. Ms. Burkholder.
Hello. Thank you. I'm Carrie Burkholder. What I want to say about this bill is that I see that it is a reactionary legislation that is trying to remove restrictions for services that property owners associations can impose charges for. Most people supporting this bill are the people who are making money off of these associations, which are the property management companies and the lawyers. The arguments for it are misinformed. This bill is not needed for legal requirements or anything related to an association's common areas. Though one gentleman brought up a security guard. A security guard is going to be on your common property in the security gate. I mean, if it's on common property, this bill, it's not prohibited by the original bill or by the lawsuit. I also want to point out that associations are not governments. They are private, not-for-profit organization, and they should not be given power that amounts to a taxing power. The decision to add a financial burden to homeowners should not be made by a small group of people on a board, which is generally about 5 people who tend to be controlled by their lawyers and their property managers. If this bill is passed, homeowners are going to lose stability in knowing what they are required to pay for. Right now, the Property Owners Association Act, where it currently allows certain fees and charges against homeowners, controls the specific events and the amount to be charged down to the penny for resales, for rentals, and for fines. It's in there. And if you need to put something for trash collection, which I think is, for the most part, is legally required, then pass a bill for trash collection. This bill, SB 672, provides no controls over services. I'm asking you, please do not rush to approve this bill. It got railroaded through the Senate. Only the lobbyists were allowed to speak. Those of us who are opposed to it were not permitted to say anything at that time. This bill is going to spur more litigation because of the way it's written, the language that's written with no definitions for most of these of the terms in it. It's going to upend the consumer protection that the legislature put in place 16 years ago when it passed 55.1/1805, which is the statute this is trying to replace. The statute did exactly what it was supposed to do with my case. It shut down an illegal expenditure. And when I'm talking about the inspections that were done to our lots, I'm talking about people going with clipboards lot by lot, writing people up because their door knockers weren't shiny enough, or because they had a little bit of condensation between double pane glass windows. We had all kinds of problems like that. Okay, so just to finish up, I've been a lawyer for 25 years and an HOA president for 10 years, And the Virginia courts did not misinterpret the law. I just requested to either reject this or at least table it for now until some time and thought can be put into it, because it's not what it purports to be, and it's going to be very, very harmful to homeowners. Thank you.
Thank you. And then we have one more speaker, Mr. Greg Helson.
Thank you, Mr. Chairman and subcommittee members. From what I can tell, the arguments in support of this misguided bill really boil down to the following two ideas. First, supporters of SB 672 argue that without SB 672, there'll be this parade of horribles because HOAs would not be able to use HOA assessments to pay for things like trash collection, security, and other services. But to the extent that such expenditures do not relate to the common areas and are not explicitly authorized in an HOA's declaration, and therefore would be prohibited under the Burkholder case, the solution is very, very simple. Just amend your declaration to permit those expenditures. Indeed, if a given expenditure truly is that important and that common sense and that basic, as the supporters have discussed, then it is truly supported by most residents in an HOA, amending the declaration would be very quick and simple. It's really not that difficult. But those in the HOA industry who are agitating for that SB 672 apparently don't like that solution because they know that many of the expenditures that HOAs currently engage in would never garner the support of most homeowners. So the second argument we hear is that SB 672 is necessary because the Burkholder case now prohibits HOAs from taking on obligations that cities and localities require them to take under local law. But that argument doesn't make any sense either because every HOA declaration already requires HOAs to follow the law and comply with any special use permits imposed by the relevant local government. So in my view, what SB 672 really, it's unnecessary. What it's really about is power. The power that the HOA industry had prior to the Burkholder case to allow HOAs to do almost anything they wanted, whenever they wanted, with homeowners' money, even though the declaration didn't contemplate it. For example, just to give you a concrete example, my HOA budgets over $6,000 per year for food and drinks for board and committee meetings that can be used by board members for private meetings that residents aren't even allowed to attend or invited to attend, including alcohol and private dinners. Such an expenditure has nothing to do with the common areas and certainly is not explicitly mentioned in our declaration, and therefore they're rightly prohibited under the Burkholder case. And the Burkholder case finally put a stop to that kind of abuse to protect the rights of homeowners, especially including low-income and disadvantaged homeowners. Don't let SB 672 completely reverse that progress and subject citizens to the whims of abusive HOAs again. I urge you to vote against SB 672. Thanks.
All right, thank you. So I think we've heard from everybody for and against. I see we've got two folks who want to be recognized. I do hear the idea that localists just amend the declarations. There's also another remedy for runaway boards of directors, which is to hire different people to run your boards of directors. So I mean, that can go both ways. All right, I see first Delegate Thomas.
I'd probably go second, Mr. Chairman, but while I am normally no friend of the HOA, including my own, this is a good bill, so I have a motion at the appropriate time.
All right, let's see if before that Delegate Quinter has something she wants to say.
I'll echo the comments of the other real estate attorney down at the other end. The only thing I will say, when you look at all the different fees, the court case, just because I think we need to make it clear, we're not going opposite of a court case. The court case left us in uncertainty, and part of our job as legislators is when there's uncertainty to bring certainty and clarity, and that's what the bill does. Your bill is doing what most folks have been doing in practice, and so I just want to make sure on the record that we're clear. We're not going opposite a court decision.
All right, so I heard a motion to report from Delegate Thomas.
Move to report.
Seconded by Delegate Quinter. The clerk will open the roll. The clerk will close the roll. That bill reports 8-0. All right, you got a couple quick ones?
I have one more bill, sir.
Okay, yep.
Okay, this is SB 570. It brings closes a loophole and clarifies our intent from when we passed the Virginia Values Act in 2020. It has to do with definitions within the bill. When we passed the bill, there were already inconsistent employer thresholds within the Virginia Human Rights Act, and we're an outlier among states in having such complicated protections against a variety of categories of employer discrimination. For example, under the law today, someone working for an employer that has between 5 and 15 employees is protected under the law if they're harassed and then fired, but not if they're demoted because of their race or religion or for refusing an unwanted sexual advance. So the bill does two things. It lowers From 15 to 5, from 15 to more than 5 to 6, the employee threshold where these types of violations would be actionable. And then further, with the enactment clause, makes it clear, which is what we intended when we passed the bill, that person also includes government or political subdivisions not being able to discriminate against their employees. We stated that openly when we passed the bill, and it was our intention to include that, but there's been some misunderstanding of whether or not governments are covered. So those are the two things the bill does.
Gotcha. Understood. So, yeah, as I understood it, the Virginia Human Rights Act was supposed to sort of run parallel to federal human rights statutes, but give folks a state cause of action on a lot of these things. And localities can be sued for these things under federal law, but right now the way it's set up, they couldn't file a similar claim under state law. So it kind of lines things up and says this applies to localities. This was always intended. Is there anybody in the audience wishing to speak in favor of the bill? Is there anyone here? Oh, I'm sorry. Go ahead.
Good evening, Mr. Chairman. Jared Calfee, the AARP Virginia. We strongly support the bill. The patron explained it very well. It will close that loophole that exists in the law currently. Age discrimination is not protected in the same way that other classes of discrimination are protected, and this would sync things up as you described. And so we do support the bill. Thank you.
All right. Is there anyone in the audience here wishing to speak in opposition to the bill? All right. Seeing no opposition, I see folks that have been online, and I appreciate that you guys have been on all day and waiting to testify and say something. So I will go ahead and let you talk, but this is our last bill. It's been a long day for the committee. If you could be very brief, we'd appreciate it. Just identify yourselves and tell us what you think. Go ahead, Lisa Sales.
I'm going to keep it brief and hear you out and just say we support the bill. Lisa Sales, Virginia National Organization for Women. Thank you.
Thank you, and thank you for your patience. And Mr. Simopoulos.
Yes, and I will echo Lisa and thank Senator Evan for moving this bill. My name is Nick Simopoulos. I'm here on behalf of the Virginia Trial Lawyers Association. We fully support SB 570 for the reasons already introduced.
All right. All right. Committee operates by motion.
Second.
It's been moved and seconded. The bill report. The clerk will open the roll. The clerk will close the roll. The bill report 6-2. Thank you, Senator Evan.
Thank you, members of the committee.
He's here for the next meeting, which is waiting for us to finish. So with that, I think that completes the work of the Housing Subcommittee. We hear a motion to adjourn, properly seconded. Those in favor say aye. No? All right, we're adjourned.